Hello, my beautiful souls out there. Um, I guess I want to talk about court a little bit. I thought I had a misconception about court, even though I'm still going through it right now for myself, but I'm getting the understanding of it. And this is just for anybody that's going through this similar situation, just trying to figure out how to do things. I know I had a little, before I even start doing court, they had this underlying feeling about just doing court, having to talk to people, going in front of the judge, all that stuff, like what we do for public speaking. So what I realized while I was doing a lot of inner work with myself, trying to get to the point where my nervous system don't just go off for just the simple things. So now I'm pretty calm and collective, and also while I'm calm and collective, a lot of great insights come to me while I'm in that calmer state. So what I've been learning about court, there's the civil rules and procedure that the court goes by. There's all kind of rules. The federal has one, and your county that you live in also has one. You take those rules and you just go by those rules, what you can, what you can't do, when you're supposed to do it, how you're supposed to do it. So there's a stage where you talk about merits. Merits is the argument stage. Oh, I did this because no, I don't owe you anything because you have the promissory note. That's the merit stage. What's not merit is say, hey, I don't know, I see pay to the order on that promissory note. It shows kind of signs of a endorsement. I'm not really sure that you're the real true owner. I need to see the audit report because I don't think you're having a claim to even move to the merit stage. Because if you go to the merit stage right away and start arguing, you waive those rights to even question jurisdiction. You literally have to do this the first time that you literally have to do this the first time that you go into court. And if you skip over that part, the court assumes that you waive those rights. So if you do argument, they assume you to be in the merit stage of where you have to figure everything out. And in my case, it's like, hey, wait a minute. Before we start even arguing about who owes who owes the debt, please show me that you have a claim. Show me that I owe you. And those things includes, hey, you're saying I owe you a debt, please show me the accounting of the records. I need to see the full accounting of the records so I can do it. But in my case, since I moved my mortgage into trust, they didn't even join they didn't join my trust. The trust I relinquished all my rights, titles, and interests into the trust by a quitclaim deed. So whenever I did that, all the stuff that this is not legal advice, by the way, this is just what I did. So since I'm in court, so they have me in court, my individual capacity, suing for a debt that they allegedly that I didn't pay. But for one thing, Rocket, I ain't gonna say, I guess I kind of said it, but the servicer is just a servicer and they don't really own the note. So if the servicer's suing you, they have to have proof that you actually owe them the debt. Did they still have it? But since the promissory note say pay to the order of, I'm not quite sure. So I need to see the evidence. And so all my documents says that, I think I skipped around. I was talking about Miss Joyner. Let me see, Luna. She got a sticker brow. She got a sticker brow on her feet. Also about Miss Joyner. Once they, since my trust has the, yeah, I'm not gonna edit this. since my trust has the deed, the trust never came to the parties list. And they sent the summons and everything. They did everything right, but changed the record. I will go by the record before anything else, because the record is the controlling instrument. And if it's not on the record, it doesn't exist. So even though they're missing the trust in these documents, they don't really address the trust on the docket. Yeah, so that's what's going on here. I'm kind of a little winded because I'm walking. I just got off of work doing some concrete work. That's besides the point. Yeah, so the trust hasn't been adjoined to the parties list. Y'all all having a party without my trust. That's pretty much what they saying. And the real person that has the birthday party ain't even there to even have the party. That's a good explanation. They call it parties list for example, for a reason. They having a party without me, the real person of interest that actually owned the house. Actually, not without me, without the trust. But I'm just basically I'm saying that those little details is not the merits. Those are questionable things. Like, hey, do you actually really have the note? Do I actually really owe you the money? And so that's what's going on. It's not even to the stage of argument. You have to prove your claim. And if you can't prove your claim, we have to dismiss this case, because you're not the true owner. I can't just walk up to a random person and just say you owe me money and take them to court and then show little documents that don't really mean anything without additional proof. Because if you look at that promissory note, it says for value received. Did you really receive that value? I'll be saying, hey, can you please show me that I received the value? Oh, you received the value. You got a house. No, I didn't. I don't see the bank name on that deed. I see it from the last party that sold it to it. Exactly what's mine. I looked on my deed. The only person that sold me the house or gave me the deed of the house was the person that was the last owner. And if the last owner gave me the deed, you really gave me nothing. The mortgage attaches to the note, nothing else. Yeah, that's some four-wheelers coming by. Hey, Josh. Yeah, some kids in the neighborhood, they like to ride their four-wheelers. And they having a blast. Yeah, so, yeah. I'm just saying that for court purposes, there's stages of these court, and you can go through the stages via hold on. Yeah, whenever you go to court, there's these rules and procedures rules of civil procedures in your county, and you can go by. You can go look up 12B6 to state a claim. Most of the time they try to throw your case out by not having that. If you hate that and you structure your case and make sure that all that stuff in place, then you shouldn't have no problem of them dismiss your case. So yeah, so that's what I wanted to tell. Court is just simply a process, and there's certain stages of the process that you cannot move on unless it's established. If it's never established, then the case can never move on. So whenever my trust has the deed, and then they only have me in my individual capacity there, then the trust is not a party of it. So the trust is lacking due process. 14th Amendment, due process. If I'm gonna go sue you, I gotta let you know. I just can't come out there and take you. I gotta give you notice. If nobody gives you notice, they violate your rights, because you have the right of due process. That's what. So if the mortgage, if the trust is not on the docket, then it violates the trust rights of having due process, because of the fact that y'all in there talking about the trust without the real owner being present. but I have to come in with these documents and just prove all of that, put all my proof onto the docket, I notarize my documents, and I put notices and facts on there, because I cannot make an argument, because if I make an argument, it waives that right to question the jurisdiction or to claim all of that stuff. You waive it all, and they call it misjoiner whenever don't have a party listed. So yeah, so on my docket list, there's no trust there at all. Got all the other parties there having a party without my trust. But yeah, that's a small little understanding that what I'm getting out of court. Just a little small process that they have to go. I haven't went through the full process, but hey, I'm willing to learn always to go through that process. But yeah, and also one last note, if you're gonna take somebody to court, you call it an administrative process, or however you seem it to be, the administrative process, those is just really evidence showing that you asked for the stuff and they refuse you, and then you continue to ask for it and they continue to refuse it, and then you go to a regulator and they didn't do anything right, and you go to you went all throughout the neighborhood asking for, hey, I'm just giving that for example, that you need to answer me, and they say no, and then you're like, well, I can't get remedy, so I got to go to court. So you got to actually show that you tried to do all those things possible, and the more that you try to resolve the problem before court, the better it looks for you. And that's what I'm doing with my credit report. In my credit report, I asked for permissible purpose. Permissible purpose just means that, hey, you're supposed to, when I ask for it, you're supposed to tell me who accessed my credit report and what permission, that purpose that you logged in for them to do it. No permissive purpose, we can't even get to the dispute stage yet, because I need to see who accessed it, and then I go from there, not straight to disputing. So so I'm not going straight to disputing either. I'm going straight to, hey, what authority had you to give them my access to my stuff, which is personal. So they have to have it. It's law. It's in 15. It's in Title 15. So, and then if you can't give it to me and you tell me no, it's even on your website too. So, but yeah. I guess I'm gonna go ahead and let you go. I'm not gonna edit this. It's just something that can give somebody value, and if you got value out of it, good. Thank you. I'm glad that you did, and it helped you understand a little bit. I'm on a walk, so I probably put something together a little bit more detailed. But all right, have a great day.